This is case number 26CR43477, the State of Ohio versus Ashley New. Ms. New is before the court with her counsel, Mr. Brewer. Ms. Nicholson, on behalf of the State of Ohio, we're here for sentencing. Has everyone had an opportunity to review the pre-sentence investigation?
Yes, Your Honor.
Yes, Your Honor.
Anything on behalf of the state?
Your Honor, we acknowledge that this is Ms. New's first criminal offenses that she has been convicted of. However, this was a significant amount of fentanyl that she did bring into the Warren County Jail after being given an opportunity to tell law enforcement of its existence. She then tried to conceal it. We did reduce it to a felony of the second degree, but we would ask the court to take all of that into consideration when issuing an appropriate prison sentence. My understanding is she has 106 days of jail time credit.
Thank you. Anything from probation?
No, Your Honor.
Mr. Brewer?
Judge, I did, prior to today's hearing, file an affidavit of indigency for the fines and costs. Aside from that, she does have no prior record at all prior to going into this. In speaking to her in my interviews early on with her, I think it was abundantly clear that some of the men that she associated with in her life are not exactly the positive influences, and she's going to have to choose her partners a little bit better than she has. Aside from that, Judge, she is asking for the minimum sentence in this particular case, and we think that the facts of this case and her record support that.
Thank you, sir. Ms. New, is there anything you'd like to add?
Yes, Your Honor. I would just like to apologize for the things that I've done, the choices that I've made that landed me here today. I want you to know I do take full accountability of my actions, and
We'll try to make better choices in the
Yes.
future.
what he said. That's all, Your Honor.
All right, the court has considered the statements made here today, the pre-sentence investigation, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. Unfortunately, Ms. New, for your first felony conviction, you've gone big, and now you're facing a mandatory prison sentence. The court, taking everything into consideration, is going to order you to serve on On count one, the court's going to order you to serve 24 months in prison. On count three, the aggravated trafficking, the court's going to order you to serve a minimum term sentence of 2 years, a maximum term sentence of 3 years. That prison sentence is mandatory. And on count five, the court's going to order you to serve 12 months in prison. Counts 1 and 5 will be served concurrent with count 3. The court is going to give you credit for the 106 days that you have already served as jail time credit. The court finds, based upon the affidavit submitted, that you are indigent for the purpose of any fines, costs, or other financial sanctions, including the mandatory fine. Now, since this is a mandatory prison sentence, you're not eligible for the Reagan-Tokes good time credit. You will be released when you finish your minimum term unless the Department of Corrections determines that you must remain in prison for bad conduct. The court is not involved in that decision. If you're not released when your minimum term ends, you will serve an additional specified period of time, and given a new release date, you will serve until that date unless you are again denied release. And the process could repeat until you are released or you finish your maximum term sentence. You are also subject to a mandatory period of post-release control, which means upon your release, the Adult Parole Authority will supervise you for a period of up to 3 years, but not less than 18 months. If you violate those rules of supervision, the Adult Parole Authority can return you to prison for up to 1/2 of the court's original minimum term sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year. Ms. Nicholson, is there anything else?
No, Your Honor, thank you.
Mr.
No,
Wood?
sir. Thank you,
All
Your
right.
Honor.
Best of luck to you.
Thank you, Your Honor.
This is case number 26CR43736, the State of Ohio versus Joshua Butler. You are Mr. Butler.
Yes, Your Honor.
What's the status of the indictment?
Your Honor, it's still pending presentation to the grand jury. It was bound over at the end of July, or end of June, I'm sorry. June 25th was the preliminary hearing.
Are you on monitor right now, Mr. Butler?
Yes, Your Honor.
Could you call Community Corrections for me, please? Oh, never mind, he sent me an email. So you're continuing to test positive for THC, is that correct?
Yes, sir. It's been less than the allotted time. I got arrested less than 30 days ago, so it's just not ran its course out of my system. I've self-admitted both times I've went in there. It just has not had it hasn't had time to run its course. I was smoking very heavily the last 30 days on a regular. There's been no continued use of any drugs or alcohol.
Is Sarah Hall here?
She is, Your Honor.
Step forward, please. Can you identify yourself for the court, please?
Sarah.
And Ms. Hall, what do you want me to know?
I work from home full-time with our 9-month-old. I just need him to be able to come get him on days that I need help. I have no help. There's no conflict between me and him. We're separated. We don't live together. I'd like him to be in his son's life. There's no concern there.
Are there any other protection orders issued by any other courts?
Not that I'm aware of, Your Honor, and in speaking with Ms. Hull, previously, she did indicate to the state that her primary concern was getting help with childcare for her son, and that the protection order keeps Mr. Butler from coming to her house to watch the child, and she believed that to be the safest place for him to care for the child, given the other circumstances. So.
How old is your son?
9 months old.
Ms. Nicholson, can you tell me at least what the allegation is?
Your Honor, yes, give me just 1 second. There was a third-party complaint a third-party call to 911. There was a police response. There were allegations of a physical assault. There were photographs of some injuries, small injuries taken. And I believe it was originally charged as a 4th-degree felony. I believe it is actually a 3rd-degree felony just based on the prior convictions. But
All right, Ms. Hall, were you the victim of domestic violence at the hands of Mr. Butler in the past?
No, sir.
So those were other women
There was
or family members?
There was another relationship in the past. Me and him have never had any history of any violence.
You say in your letter to the court, I guess this is an email, correct? that there was no physical violence or physical aggression involved.
Yes,
That's
Your
not
Honor.
what the allegation is. Do you agree that that's different than what the again, I haven't heard the facts, I don't really know, other than that's why it's called an allegation, right? Can you explain that?
I'm just, I have a long past in a previous relationship, with severe violence that just escalated the situation at the moment and a lot of outside pressure.
Okay. Has anyone promised you anything or threatened you in any way to get you to request to court to modify this order?
No, sir.
Are you under the influence today of any drugs or alcohol?
No, sir.
You understand that if the court withdraws this protection order, it eliminates at least a layer of protection for you, and that Mr. Butler would be, there's nothing that I could do if he has contact with you. You understand that?
Yes, sir.
This is what you want me to do.
Yes, sir.
Does the state have any position on this?
Certainly, we have concerns based on the nature of the allegation and Mr. Butler's history, but Ms. Hall has been here to tell you her wishes.
Okay. All right, the court will withdraw the protection order at this time. There is no contact order at this time. Mr. Butler, I will caution you, you are on monitor, you will stay on monitor, and all other previous bond conditions will remain in effect. So one of them is that you're not allowed to drink alcohol, and you're not allowed to use any illegal drugs, you're not allowed to smoke marijuana. So if you continue to do that, just be mindful that I will enforce that order. Are we clear on that?
Yes, Your Honor.
All right, it's probably best that you behave yourself while you're here, because you certainly don't want another allegation coming before me, right?
I'm on my best behavior.
Okay, all right, that's all.
I do have one question, because there's exclusion zones for my ankle monitor. Will those be removed, or at least for that residence, so that I can pick my son up?
Yes, the community corrections will be advised that the protection order is being dismissed, so the exclusion zones will be eliminated. Right?
Thank you, Your Honor.
Thank you.
Thank you.